Dear friends and colleagues, we continue a series of interviews for international audience, and today we have Mr. Erkin Gadirli, who is member of the Real Alternative Party in the Milli Meclis of Azerbaijan. Real Alternative Party is the opposition party. Erkin Gadirli has legal background. He used to be instructor at Baku State University. He was involved in the study of several legal issues, International Criminal Court, and was a representative of Azerbaijan delegation at the establishment of ICC in 1999. And he is the author of numerous articles, research papers on different legal issues, international law and national law. And today, Erkin Malam, we would like to discuss the current situation between Armenia and Azerbaijan in the legal context. So, what, in your opinion, in terms of the peace process, we have several tracks. We have the peace treaty, we have delimitation, we have issues of opening of the transportation links. So, and it looks like both sides can't come to certain agreement, especially the core issue is the territorial integrity. Azerbaijan offered 5 points treaty proposal, core of the treaty proposal. On one side, Armenian side in the beginning of 2020 said that we are accepting Azerbaijani proposal. We are ready to recognize Azerbaijan's territorial integrity. But when discussion came around the Nagorno-Karabakh, so-called Nagorno-Karabakh region of Azerbaijan, they insisted on the special treatment of this territory, and even on the international forums, they continue speak about the independence of quote-unquote Nagorno-Karabakh, etc. Recently, again, was conversation that if Armenian side accept the Almaty Declaration, borders of 1991, it means that the Armenian side accepts Azerbaijan jurisdiction over Karabakh. Once it has been told by the third country representative, the Armenian side, Armenian officials said, no, we don't recognize Karabakh as a part of Azerbaijan. So we see this dichotomy. On one side, we would like to sign peace treaty, we would like that Azerbaijan recognize Armenian territorial integrity, but when it comes to Karabakh, there is the kind of, we see quite unclear statements. So what's the view on this situation?
First of all, thank you very much for inviting me. Yes, indeed, it's a very complicated issue, not in principle, but because of the position that Armenian side takes. As you rightly pointed out, they initially, right after the war, when the negotiations started, the Prime Minister of Armenia, the Minister of Foreign Affairs, on numerous occasions publicly said that they do recognize the territorial integrity of Azerbaijan. And then they started referring to the Almaty Declaration of 1991. The problem with the Almaty Declaration is that, yes, indeed, although stating that former Soviet republics recognize territorial integrity of each other, the text does not go to indicate within which borders. Because had it been written there that former Soviet republics recognize territorial integrity of each other within the administrative borders existed in the Soviet Union, that the situation would have been much clearer. Unfortunately, that part is missing in the text of Almaty Declaration. That is why, as a lawyer myself, I'm not quite optimistic about that particular document. I know the political implication of it, and I know what political scientists and politicians mean when they refer to that, and that's how it should be. But again, knowing that how Armenian side tends to play upon the words, Of course, that text, I mean, the Almaty Declaration, is not firm one. For the viewers of this video, perhaps it would be useful to remind how the rhetoric of Armenian side changed over time. Since the very beginning, when the conflict just started 30-something years ago, their rhetoric was about the restoration of historical justice, reunification of Armenian lands. Yes, exactly. Miatsum. So it sounded very much like a territorial claim of Armenia towards Azerbaijan. That's how it started. It led to the war, occupation, ethnic cleansing, devastation of the territory, and etc. Then when the first war ended, 30 years ago, and negotiation started within the Minsk group, Armenian side ceased to refer to the historical justice of Miatsum. They started claiming that what they called the people of Nagorno-Karabakh has the right to self-determination, and that's how they exercised that right. They voted to secede from Azerbaijan, and then they even went as far as to say that it is for the people of the so-called Nagorno-Karabakh to decide if they want to be part of Armenia or maybe they want to be an independent state. But in any case, they denied that Karabakh belongs to Azerbaijan. That took 30 years to negotiate. And of course, we all know that the reference to the right to self-determination is legally ungrounded, because the Armenians in Karabakh are not people under international law. They are ethnic minority. And being so, they are protected by the Constitution of Azerbaijan and relevant international human rights treaties. Self-determination is a wrongly put context in this case. But the Armenian side insisted that Armenians in Karabakh are people, and even when they submitted their reports to the International Committee of Human Rights under the ICCPR, the International Covenant of Civil and Political Rights, Article 1 of which says that all people have the equal right to self-determination, they always included Armenians of Nagorno-Karabakh within the context of their own country report. And the Human Rights Committee every time noted that Armenia should limit its reporting obligations by its own legal territory. So Karabakh is a separate issue. But anyway, Armenians continue to include Karabakh within their country report. And
basically, it's kind of admittance that we are exercising control over that occupation.
Exactly. And even in the 1998, the Constitutional Court of Armenia approved the declaration of the Armenian Supreme Soviet of 1988. 88.
So 1st December 1989.
Which declared Karabakh a part of Armenia. And that was done within the context of presidential elections, because there was a dispute whether Robert Kocharian, then the candidate to the presidency, is eligible or not, because he never lived in Armenia proper. He's from Karabakh. And to make him eligible, the Constitutional Court incorporated that declaration into its own judgment, decision, and by so doing declared that Robert Kocharian resided in the territory of Armenia for at least 10 years as required by the Constitution of Armenia. And that decision is still in force. No matter what Prime Minister or other officials of Armenia say publicly, as a lawyer, I have to take into account the fact that those are just words. Although they may indeed reflect good intention, which we always welcome, but legally speaking, they do not count, because for Armenia to explicitly show that they're committed to what they say, they should null and void the decision of the Constitutional Court of 1998. So this is another complication, complicated issue, which also hinders the negotiation process. Now, Armenian side, this is the third stage of the development of Armenian rhetoric, is now they say that, okay, Karabakh for us is no longer a territorial issue, it's an issue of human rights and security. By doing so, they are trying to kind of put this claim, it's essentially the same claim, the claim about a status for Armenians in Karabakh, and most probably they have in mind independence from Azerbaijan. But they phrase it in a humanitarian terms, like most likely they have in mind a strategy which will, in their mind, bring them to a stage when they could claim that what is called in political literature, what is in political left liberal political literature called
remedial secession.
Yes, remedial secession. Sorry, yes, remedial secession. And there is no such right under international law.
So it's not legal term.
It's not a legal term. There is no such right under international law. It's just a term used by leftist political scientists, political philosophers, and liberal political literature. And what they have in mind is that when a group of people faces real danger of extermination, then there is no other choice for them but to secede. Of course, there is no such real danger, and there is no such right under international law, but Armenians are trying to bring that attention to the like-minded circles in Europe, or possibly in America, and to attract this attention to the situation of what they claim a threat to the very fact of existence of Armenians. And we now see how they use this Lachin corridor context. They claim that Azerbaijan blocked the road. They claim that
we'll come to that.
Yes,
Lachin camp. So, in your view, so we need some sort of the special provision in the possible peace treaty, because Almaty declaration is not sufficient, is not enough to put an end with ambiguity. So the closure or the provision which will end Armenian territorial claims towards Karabakh region of Azerbaijan. So it should be clearly expression of the recognition of Azerbaijan's jurisdiction.
They should be a line, a sentence or a phrase, including Karabakh, because unless Armenian side clearly state that they recognize Karabakh as part of Azerbaijan, their words about recognition of our territorial integrity are just empty words. We need a clear indication of their intention. One would be abolishment of this decision by the Constitutional Court. The other one would be putting in the text, writing in the text this phrase, including former Nagorno-Karabakh area, because otherwise this dispute will never end. Because we all know that even international mediators, they always kept saying that, oh yes, we do recognize the territorial integrity of Azerbaijan, but they never said within which borders. But when it came to Georgia, for example, they always indicated that we recognize territorial integrity of Georgia, including Abkhazia and South Ossetia. In the case of Moldova, they always indicated that they recognized territorial integrity of Moldova, including Transnistria and the Crimea in the case of Ukraine. But when it came to Azerbaijan, they never went further by saying to say that including Nagorno-Karabakh.
But we're speaking about the group of Western countries, because the international community speaking, if in terms of the any formal endorsement, we have United Nations Security Council resolutions, we have other UN documents who clearly indicates that Nagorno-Karabakh region of the Republic of Azerbaijan. Now let's come to Lachin corridor from legal perspective. Of course, we know what's going on. The Azerbaijani activists blocked the road. Armenian claims that they are under threat of starvation and they cannot move the cargo, I mean the civilian cargo, etc. The Azerbaijan side claims that it's open for civilians, it's blocked because of the illegal transfers, and we have here indeed not only extraction of Azerbaijan natural resources, but there is the evidence also that the Lachin route is used for the military supply. That's two kind.
And we know that Armenian military forces, the remaining part of it, is still there.
In violation of trilateral statement of November 2020, which says all Armenian. It doesn't say Republic of Armenia, saying Armenian forces should be withdrawn. So that means all Armenia. So in terms of the legal context, what's your view on the status of Lachin road and the current situation, and also would like to specifically comment on the decision of European Court on Human Rights the Armenia applied to with regard to the problem on the Lachin road. So
Lachin road is a humanitarian corridor which Azerbaijan agreed to provide access to and from Armenia, between Armenia and the Armenia proper and the Armenians in Karabakh. And it's an obligation undertook by Azerbaijani side, and that trilateral agreement also includes that this should be a mutually agreed corridor from Nakhchivan to the mainland of Azerbaijan, so-called Zangezur corridor, which Armenian side refuses to implement. So now Azerbaijan, in a very good will, unilaterally provides access from Armenia to Armenians in Karabakh. And Lachin corridor is a sovereign territory of Azerbaijan. No other foreign power has any right to claim jurisdiction over it. Temporarily, it is controlled by Russian peacekeepers. I mean, the access and exit, that's how it was agreed in trilateral agreement. But unfortunately, not all the obligations are being implemented. We already mentioned the Armenian armed forces, the remaining part of it. They are still there, and also Russian side does not implement it because it's Russian obligation. Also, Azerbaijanis from Karabakh are not allowed to enter, I mean, the area which Russian peacekeepers control. For more than 2 years, they don't have access to that area, but this is obligation undertook, which Russia undertook. In this situation, where we know that the natural resources of Azerbaijan are being illegally exploited, and there are military supplies to that area, in principle, Azerbaijan has a legitimate right to stop and check all those vehicles. But Armenian side claim that the corridor is blocked, which is simply not true, and even technically impossible, because, as I said, it is controlled by Russian peacekeepers, and if only Russians can technically block it, because Russians have effective control over that particular area. And if what Armenians claim is true, then that claim should be made to Russia, not Azerbaijan. And the international community should also know that, because we're not the ones responsible for again, if I say what Armenians claim is true, then we cannot be responsible for that. We do not control that area. It's under effective control of Russian peacekeepers. And this is another very intriguing situation, by the way, because when the territories were under Armenian occupation, you know, the cases in the European Court of Human Rights, Chiragov and others case, where European Court of Human Rights held Armenia responsible for human rights violations on the occupied territories because Armenia exercised effective control over those territories.
So that's the decision 2015 for the our viewers.
Yes. Now those territories are liberated and the remaining part of Karabakh are under effective control of Russian peacekeepers. The problem is that Russia is no longer a member of the Council of Europe. Russia is no longer a party to European Convention of Human Rights, and Russia is no longer under the jurisdiction of the European Court of Human Rights.
That's kind of
so yes, it's a legal hole. It's a lawless area, so to speak. So it's a problem legally. If you decide to sue Russia, for example, in European Court, that will be technically impossible, unfortunately. So this is where we are in terms of legal framework of this situation. And unless the peace treaty is signed, which should be a very comprehensive document, it should include mutual recognition of territorial integrity, inviolability of state borders, the very same 5 principles, points that Azerbaijan offered to Armenia, which are nothing new. I mean, those are fundamental principles of international public law. So Azerbaijan didn't invent any other principle, it simply used them. Those the ones that are enshrined in the Charter of the United Nations Organizations and Helsinki Final Act. So, and delimitation and demarcation of borders is the technical, yet another stage of possible development. But first we need to agree on the fundamental principles.
So first comes peace treaty, mutual recognition of
which may or may not include those technicalities as demarcation and so on. Because it may take some years because it's giving the fact that the border goes through high mountains. So technically it will take quite some time. But there must be a political agreement which will be legally enforced. And for that, we need Armenians' consent and acceptance of jurisdiction of Azerbaijan over the remaining parts of Karabakh, which are currently and temporarily under the control of Russian peacekeepers.
Well, thank you. Basically, we have now your comments on peace treaty and also Lachin situation. The third very important issue, especially for Azerbaijan, and Azerbaijan on numerous occasions raised this issue before international community, it's the issue of the damage to the destruction of the whole infrastructure on the liberated territory, on the formerly occupied territories. Since Armenia, by the decision you mentioned, European Court on Human Rights, Chiragov against Armenia, adopted in 2015. So basically effective control, that means the Armenian responsible for these destructions. We have now 2 cases which filed Azerbaijan in Hague, in
International Court of Justice,
and also in European Court of Human Rights. Your opinion on how this process is going and what we can expect? Any other avenues Azerbaijan can pursue to hold Armenia responsible or for reparation of damages, which is also a very important issue for us?
Yeah, the proceedings in the International Court of Justice, as you rightly pointed out, is ongoing. Azerbaijan launched its complaint, and by the way, Armenia has also launched its complaint. So it's
mutual
complaint. And the tricky situation is that neither Armenia nor Azerbaijan recognize the jurisdiction of the International Court of Justice. So it's not a typical interstate complaint. It's a mechanism which exists in the Convention on Elimination of All Forms of Racial Discrimination, and it's about dispute on the interpretation and application of that convention. So that's a very different context. It has nothing to do with the core substance of your question. Now, the application of in the European Court of Human Rights, it's just very recently launched. So it's far too early to say. I'm not going to predict the decision of the European Court of Human Rights. It's a court's decision anyway. But what I do expect is that to legally sue Armenia, because a lot of preparations must be done, and I know that they are being done. I mean, calculation of damages, material proofs, and also in that same application in the case in the International Court of Justice. In Azerbaijan, I indeed provided us a number of material proofs, which in fact confirms the effective control of Armenia over the previously occupied territories, because and we also know that the doctrine of effective control is differently used by European Court of Human Rights and International Court. There are certain elements of it, because International Court of Justice requires some additional elements, and they may take into account some issues which for the European Court of Human Rights are not relevant, because the European Court of Human Rights, we all know, it's a human rights court. It does not deal with the international responsibility of states. I mean, vis-a-vis each other. So the responsibility of states under the jurisdiction of human rights is in the context of human rights, so vis-a-vis individuals. Whereas the International Court of Justice, it deals with international responsibility of states with each other. So that puts the threshold a bit higher. So let's see how International Court of Justice will interpret it. But I'm expecting that it will still be in favor of Azerbaijan, because again, we have all the proofs, including satellite images. I've seen some of them. And I don't expect that it will be very hard for Azerbaijani side to prove the effective control of Armenia over the previously occupied territories. Then, of course, there are many other mechanisms in national courts.
I would like your comments, because I've heard the opinion that Azerbaijan can sue certain companies who work.
Yes, exactly.
Which worked in Azerbaijan.
Yes, it can do it in the national courts of the countries of their registration. It can do it in our own courts, I mean Azerbaijan. So yes, indeed, because all we need to prove is that those companies were doing business knowingly, which is not that hard to do. Because some of them may choose to claim that we didn't know about the illegal occupation of the state, which would be rather weird for them to do. I mean, of course they know. How can you do a business without the knowledge that the territory is occupied? But there are certain issues of property, registration, contracts, and under international law, it's not only international, it's a fundamental principle of law in general, that when the fundamental conditions, the core conditions of a contract is illegal, then the whole contract is illegal. Whoever claimed to be an authority there, that contract is illegal from the very beginning.
Okay.
So they cannot even claim to be compensated for some losses because they knew that this territory was occupied.
I see. Thank you very much. I think we touched upon very important context of the process, former conflict and current post-conflict development, and the, hopefully peace process. When we're speaking peace process, because occasionally I'm thinking we have to speak still about negotiation process of a peace treaty.
Yes.
Because we don't know. It looks like, especially recently, the Armenian side refused to move towards the peace treaty. I mean, they decided to include fourth party into trilateral format in Brussels, and then the council meeting in Moscow.
Yes,
So I think
it is in fact very, it looks very ironic when Azerbaijan won the war, and it is Azerbaijan who insists on the peace treaty.
Yeah.
This is rather unusual,
Yeah.
because normally it doesn't work this way.
Yeah.
But this is another indication of the goodwill of Azerbaijan, because we never wanted war. Neither 30 years ago, nor even 2 years ago. We kept loyal to our promises, and we kept loyal to our self-imposed obligation to settle the conflict peacefully. Why I said self-imposed? Because there is no such a principle under international law of peaceful settlement of conflict. The law says that there is a principle of friendly settlement of disputes. When a dispute evolves into a conflict, the right to self-defense comes into effect. And this is what Azerbaijan had to exercise, to implement 2 years ago during the 44 days war. It's very unfortunate because we lost thousands of lives, but this was our inherent right, the right to self-defense, as long as our territories were kept under occupation.
And by the way, I think the war they began in July, not in September.
Yes, you mean those
clashes, basically. Now we know that who initiated that. I mean, after certain people.
But we do not need. I mean, you're absolutely right, and this is perhaps needs to be stressed on so that the viewers, experts in other countries, should really know about the timing. But even without that, as a lawyer, I'm quite confident that you don't need to prove who started first. I mean, 2 years ago.
Yeah.
As long as our territories were kept under occupation, we had an inherent right to use force to liberate them under Article 51 of the United Nations Charter.
Thank you very much, and indeed I think it was a fruitful discussion, and I think thanks to Mr. Gadirli, it now became clear many important legal issues surrounding the situation between Armenia and Azerbaijan and Lachin corridor including. Thank you very much.
Thank you, Pelin. Thank you.